Thank you, Chairman Grassley. Thank you, Judge Kavanaugh. As we discussed in my office and in a letter I've sent to you to follow up, I hope to question you today about your views on rule of law, separation of powers, presidential power. And Chairman, I'd like to start by entering into the record a series of articles that I think lay some of the foundation for my concerns.
Without objections ordered. Well,
thank you.
Go ahead. If
First,
you
who is Brett Kavanaugh? By Chicago professor Eric Posner and Emily Bazelon. Second, the Kavanaugh nomination must be paused and he must recuse himself. By former Third Circuit Judge Timothy Lewis, former White House Ethics Counsel Norm Eisen, and Harvard Law professor Tribe. Third, Brett Kavanaugh's radical view of executive power by Professor Bettenschneider. Brett Kavanaugh is devoted to the presidency by law professor Garrett Epps. And Brett Kavanaugh's legal opinions show he'd give Donald Trump unprecedented new powers by Fordham professor Sugarman.
As I previously said, without order.
You repeat who the third one was? Sorry, I want to make sure I know the names.
I think it was Brett Kavanaugh's radical view of executive power by Brown University professor Corey Brettschneider, if I'm not mistaken.
Okay, that's not a law professor though, right?
Correct.
Okay.
It's a range of opinions from a range of folks from a range of backgrounds. Judge, the rule of law requires that those who are governed and those who govern both be bound by the law. And a key way to ensure, as you said in your opening, that no one is or should be above the law is to ensure that the president is not above the law by preventing him from firing someone appointed to investigate him. Sitting on a panel at Georgetown in 1998, you took a different view. You said at that time, and I quote, "The prosecutor should be removable at will by the president." Given what's in your record, a long record of writing and speaking on this topic, I think there's legitimate cause for concern about your views on presidential power and whether it's possible President Trump chose you so you would protect him. Please answer directly. Do you still believe a president can fire at will a prosecutor who is criminally investigating him?
Well, that's a question of precedent, and it's a question of that could come before me either as a sitting judge on the D.C. Circuit or if I'm confirmed as a Supreme Court justice. So I think that question is governed by precedent that you'd have to consider. United States versus Nixon, of course, the special prosecutor regulation in that case was at issue in United States versus Richard Nixon and the subpoena.
Judge, if I could, I'm just asking whether you stand by your record, something that you chose to write in 1998. You expressed a view at the time that a president can fire at will a prosecutor criminally investigating him. Is that still your view?
Well, that would depend.
I'm not asking for a recitation of precedent. We will get into some precedent later. I'm just trying to make sure I understand if you stand by that publicly expressed view back in 1998.
I think all I can say, Senator, is that was my view in 1998.
Okay. Well, then let's move to a more recent statement that I think is equally important. In the wake of the Watergate presidential scandal, a scandal precipitated by a president who committed some crimes and then was investigated, Congress passed the Independent Counsel statute, a statute which restricted, in part, when the president can fire an independent counsel. And during a recent speech, a 2016 speech, you described this law as, and I quote, a goo-goo post-Watergate reform and a constitutional travesty. Do you stand by your criticism of the independent counsel statute as a constitutional travesty?
Well, that was understated compared to what members of this committee and others said in 1999 when the decision was made.
But Judge, I'm interested in your views, not views of members of this committee. And when you chose in a public speech as a sitting judge to say that that statute was a constitutional travesty, you had something in mind. What are your views on this statute and why do you view it as a constitutional travesty?
So let me make a few things clear. This is the old independent counsel statute.
Yes.
That's distinct from the special counsel system that I've specifically said is consistent with our traditions. I said that in the Georgetown article, as you know. I said that actually in the PHH case most recently. The statute you're talking about, the independent counsel statute, was a distinct regime that Congress itself decided not to reauthorize in 1999. I think Senator Durbin said it was unrestrained, unaccountable, unconstitutional statute. That
But I'm
statute
interested,
doesn't
if I might, Judge, in your views. You chose to describe the independent counsel as a constitutional travesty. What did you mean?
I meant, I think, what Justice Kagan said when she said at Stanford a few years ago that Justice Scalia's dissent in Morrison v. Olson, and this is a quote, was one of the greatest dissents ever written and has gotten better every year. By identifying Justice Scalia's dissent as one of the greatest dissents ever written, Justice Kagan seemed to be saying, at least I think this is the only reading of it, that the Morrison v. Olson decision was wrong.
I'll actually strongly disagree. You offered that quote, that cite of Justice Kagan when we met. I was struck. Perhaps I should call Justice Kagan and tell her she's one of your judicial heroes. I think that citation is actually literally true but misleading in context. Justice Kagan wrote in a famous Harvard Law Review article in 2001 strongly rejecting the unitary executive theory, which is at the root of the Scalia dissent in Morrison v. Olson. I believe Justice Kagan was complimenting the forcefulness and the clarity of Scalia's writing in the dissent, not agreeing with the legal theory. I'm trying to get to the point of...
I think I disagree with that, Senator.
Well, I look forward to exchanging some papers on this, and perhaps in our next round tomorrow we can have more fun on it. But it's an important point.
It is, but I think in that article, and I've read that article, it's a great article, Presidential Administration by Justice Kagan,
Yes.
then Professor Kagan. I think she was referring to the concept of independent agencies generally, so the Humphreys executor line of the cases. So I think she's referring there, at least I read her as referring there to independent agencies are traditional and permissible. The independent counsel statute was something quite different from the traditional independent agencies that had existed with the Federal Trade Commission, the Securities and Exchange Commission. So I did not read her old article to in any way.
Let's put it this way. Yeah. Justice Kagan may have complimented Scalia's dissent in its writing or its holding. You've criticized the independent counsel statute as a constitutional travesty, and I'm simply trying to get to the bottom of why you held that view and why you chose to say that in a speech just 2 years ago.
Well, it was Morrison v. Olson was a one-off case about a one-off statute that hasn't existed for 20 years. Mm-hmm. The statute's gone. The case, as Justice Kagan, I think I took my lead from her comment. I know I read that. I've cited it many times in speeches I've given. But that statute, it's just real important to be clear here, and I know you know this, Senator, but so everyone understands. That statute hasn't existed since 1999. The special counsel system
is still good law, is it not? But the holding by the Supreme Court in Morrison v. Olson, even though the independent counsel statute has passed into history, Morrison v. Olson, as a decision of the Supreme Court, is still good law. In fact, your own circuit said so forcefully this year.
I think Humphrey's executor.
I think that's a yes or no question. The D.C. Circuit held this year in PHH, where you wrote a dissent, that Morrison v. Olson is still good law, correct?
I think they were applying Humphrey's executor. They might have cited Morrison, but the principle
They literally said, and I quote, Morrison remains valid and binding precedent, and
in how it applied Humphrey's.
Criticized your minority as flying in the face of Morrison.
And again, we're talking about independent agencies, so the traditional independent agencies on the one hand, and the old independent counsel regime that is long gone on the other. Mm-hmm. And the independent counsel regime, this committee and the Congress as a whole decided was a serious mistake. It's just Senator Durbin's words: unrestrained, unaccountable, unconstitutional.
So what I'm concerned about, Judge, is not so much whether there are members of this committee or other justices who viewed the independent counsel statute as a serious mistake, but whether you view Morrison v. Olson and the majority holding there as a serious mistake. So let's move to that point, if I could. In Morrison v. Olson, as you well know, the court upheld a restriction on the president's power to fire the independent counsel. In fact, by a vote of 7-1, it's an opinion written by your first judicial hero, Chief Justice Rehnquist. It was only Justice Scalia who dissented in arguably a well-crafted dissent. But for those 7 justices, they wrote an important decision, which I believe you have challenged and criticized because it restrained the president's power to fire the independent counsel. Just 2 years ago, You were asked at a public event to name a case that deserved to be overturned, any case. And after a pregnant pause, you said, well, I can think of one. There was some chuckling.
Yeah.
And then you said, well, sure, Morrison v. Olson. And I'm struck by that, having watched that speech. Not Korematsu, not Buck v. Bell, cases that, are taught to all first-year law students as terrible examples of shameful decisions. No, you chose Morrison v. Olson to say it's already been effectively overturned, which I disagree with, and I would put the final nail in the coffin. So here's a recent public statement by a sitting D.C. Circuit judge who's now before me as a nominee to serve on the Supreme Court. So I've got a question. Would you vote to overturn Morrison?
Senator, first of all, Korematsu's been now overturned, and Buck v. Bell's a disgrace.
Right.
So
So it's striking you didn't choose either of them. You reach out and say, oh, this old 30-year-old decision about a statute long gone, that's the one I'm going to hold up to get rid of.
I really did have Justice Kagan's comment foremost in mind. I thought she had already talked about Morrison v. Olson, and
Nothing to do with a view of presidential power.
well, I've written about the special counsel system, and I've said in the 1999 Georgetown article that the special counsel system is the traditional approach that's used when there's a conflict of interest in the executive branch. There's a need for an outside counsel, and I've said that's traditional. And when I said that again in the PHH case that you just cited.
And is that special counsel fireable at will or only for cause?
And
in
that's
your conception of what's the most appropriate structure?
So that's the hypothetical that you're asking me, and I think what that depends on is there some kind of restriction on for cause protection, either regulatorily or statutorily, that is permissible, that is different from the old independent counsel, for example. And that's the kind of open question, gray area question that you would want to hear the briefs, get the oral arguments, keep an open mind on. What is the specific statute you have at issue? Remember, the old independent counsel had a lot of moving parts to it that were all of which were novel and together produced Justice Scalia's dissent. No, I don't think any one aspect.
So given your enthusiasm for Justice Scalia's dissent, given your choice to say, forgive me, I would put the final nail in, let me go back to that question. Would you vote to overturn Morrison?
Senator, I'm not going to say more than what I said before.
Well, I think what you said before is clear. I think your enthusiasm for overturning Morrison is unmistakable.
Executive immunity has no place in democracy. For all of you who support this, it is un-American. It is absolutely un-American. And shame on you, and shame on all of you.
I want to repeat two things, Senator, because they're important. One is Humphrey's executor is the precedent that stands, and I've called it an entrenched precedent in an opinion, on independent agencies generally. And two is the special counsel system, both in the PHH decision recently and in the old Georgetown Law Journal article. I've specifically said that that's the traditional way that criminal investigations proceed when there's a conflict of interest in the usual Justice Department process.
Humphrey's executor has been settled law now for 83 years, right? And early on you said that you would be willing to offer views on long settled cases. Can you just tell me if Humphrey's executor was correctly decided? It's long settled precedent, yes. You've said that about a number of cases. But a key difference here is whether you'll say that something was rightly decided. I'm struck about this, frankly a little concerned about it, because in your own opinion, in your dissent in PHH, you went into a long criticism of Humphrey's executor. That, at least that's how I read it. You laid out a very strong articulation of this unitary executive theory, this theory that the president is imbued with all the power of the executive branch, which is the core of Scalia's dissent in Morrison, which is a radical theory that has been rejected by the Supreme Court, I would argue. And you go on to then say that Humphrey's executor, yeah, it's long settled. But you know, if we were to overturn it, it wouldn't mean the elimination of independent agencies. This is long. Why did you need to go there? Why have that conversation if this long settled case is actually well reasoned?
What I said in the PHH case is that Humphrey's executor is the precedent that governs independent agencies. I've applied it dozens of times, Humphrey's executor, and referred to it that way. What concerned me constitutionally as a judge in the PHH case was that the CFPB did not follow the traditional model of independent agencies and therefore departed from this traditional exception, one might say, to the idea that a single president controls the executive branch. And I explained all that the having one head of an independent agency both diminished presidential authority more than Humphrey's executor and posed a serious threat to individual liberty and was a departure from historical practice, which under the Supreme Court's precedents makes a big difference, as you know, of course. And so I referred, so that's why I concluded in the CFPB case that the statute was the Bureau was unconstitutionally structured, but the remedy was not to get rid of the whole agency. The remedy was simply to make the person removable at will.
So Humphrey's executor was centrally about whether or not the head of the FTC could be removable at will or have a good cause removal protections.
Right. President Roosevelt wanted to fire Humphrey, who was a Republican holder.
Will you simply just state that it's well-reasoned, well-decided, long-settled law?
I'll say it's an important precedent of the Supreme Court that I've applied many times, has been reaffirmed.
It's troubling to me that you can't say that Humphrey's executor was well-decided.
But again, I'll follow the 8 nominees.
Marbury versus Madison, well-decided.
Of course. Of course it is. The concept of judicial review wasn't even invented in Marbury versus Madison. It's right here in the Constitution as I read it, and also referred to in Federalist 78. We mistakenly say Marbury created the concept of judicial review. It actually exists right there. But it's a correct application. But the reason I'm hesitating.
So let me bring this back to the current context and why all of this is of concern to me and relevant.
But I didn't finish my answer.
We have a series of public statements by you that are recent about your enthusiasm for overturning Morrison. And you're not going to comment on that here. You won't answer that question here. You've got a recent decision as a D.C. Circuit judge where you forcefully articulate this unitary executive theory that would give the president significantly more power. And if Humphrey's executor is at any risk, we might then see a whole series of agencies moved or a whole series of long-established protections from at-will removal at some risk. Let me just make sure I get this right. In your view, can Congress restrict the removal of any official within the executive branch?
Under the Supreme Court precedent, which I've applied many times, Humphreys, and referred to it as an entrenched precedent, Congress historically has restricted the removal of independent agency heads, and that is law that has been in place for a long time.
For decades.
On Morrison, you may disagree with what I'm about to say, but the reason I think Justice Kagan probably felt free to talk about Morrison, and I did as well, is it seemed a one-off case about a statute that doesn't exist anymore, and that Humphreys is the precedent on independent agencies. Now, you may disagree with me on that, but I think that's the premise on which she spoke. I don't want to put words in her mouth, but that's certainly the premise on which I spoke. But I was not intending to do either of two things. I was not intending to say anything about Humphreys, and I was not intending to say anything about traditional special counsels, which I've explicitly distinguished multiple times over the years.
So I'm concerned that I'm having difficulty getting what I think is a clear and decisive answer from you on a number of things. Would you overturn Morrison? What's your view of executive theory? Is it appropriate for a president to fire a special counsel investigating him? I'm just going to come back to a decision that you rendered this year, this PHH decision. And I urge folks who are having any interest in this or trouble following it to just read your decision in this case. Because you lay out, you embrace this theory of the executive, that the executive has all the power of the executive branch, which I think is directly relevant to the question whether a special prosecutor should be fireable at will by the president or could be protected from being fired by the whims of the president. This is a theory that was rejected not just by the Supreme Court in Morrison v. Olson, not just by the D.C. Circuit, but by a number of members of this committee in a recent vote, a bipartisan vote, advancing a bill that's predicated on the idea that Congress can impose some restrictions on the executive's power to fire at will executive branch junior officers.
Just with respect, Senator, I think you're significantly overreading what I wrote in that case. I did not in any way say that the traditional independent agencies are in any way constitutionally problematic. In fact, I took that as the baseline on which I said that this new agency departed from that traditional model and was problematic. So I did not cast doubt on Humphreys in that case, at least as I read it. I guess you don't agree with the opinion, but I explained in great detail why I thought this deviation from Humphreys mattered as a matter of historical practice.
Let's get then, if we could, Judge, in the few minutes I've got left, to the question of investigations, because this is also something you've written about, you've spoken about, and it's related, I think, to this issue. Now, back in Georgetown, on a panel in 1998, you said, and I quote, "It makes no sense at all to have an independent counsel investigate the conduct of the president. If the president were the sole subject of a criminal investigation, I would say no one should be investigating that." Is that still your view, that if there's credible evidence that a president committed crimes, no one should investigate it?
That's not what I said, Senator. So two things on that. One, the independent counsel you're referring to there, it's just important because people forget this, is distinct from the special counsel system. So it's very important. I specifically in that Georgetown Law Journal approved of the traditional special counsel system.
And the traditional special counsel system has a special counsel that can be fired at will by the president, correct?
Well, in the Watergate situation, there was a regulation that protected the special counsel from
What happened to the special counsel in Watergate?
Well, there was a new regulation then put in place, as you know, and then in United States versus Richard Nixon, that new regulation was parsed pretty carefully. And then more generally—
This is exactly why your quote that the independent counsel statute was a goo-goo post-Watergate reform gave me some agita.
But that wasn't but that was a statute put in well after Watergate, of course, 1978. That in Watergate itself, what the system that was in place was the traditional special counsel system with a new regulation put in after the episode you're referring to. And then when the independent counsel system came up in 1999 for reauthorization, there was everyone agreed it was. I think I'm not.
You're not alone.
I'm not exaggerating to say that the quote you put up before that one was understating what everyone here said about the independent counsel system.
Well, in a 1999 article in that exact period, I think this is the American Spectator article, you called it constitutionally dubious for a criminal prosecutor to have the responsibility to investigate the president. Help me understand that. Is that still your view, Judge? Is it still your view that it's constitutionally dubious for a criminal prosecutor to investigate the president?
No, I've never taken a position on the constitutionality. All I've done is point out that, as I did in the Minnesota Law Review article, that Congress might want to consider the balance of, and that's when President Obama was in office.
So this is just a policy argument, not a constitutional argument?
Correct. If I have a constitutional case come before me as a judge on the D.C. Circuit, or if confirmed on that court, I'll have an open mind. I'll listen to the arguments. I'll dig into the history. I've seen all sides of this. I will have a completely open mind on the constitutional issue. And again, briefs and arguments. I think I've also shown a capacity to, if I'm presented with a better argument than something I've had before, to adopt the better argument. I've certainly done that. A good example of that in the national security context. In the first Balul case, I pointed out how I had reconsidered something I'd written before in a national security context. But the larger point is that I've not taken a position on constitutionality before.
Well, and I'll just come back to a point we've now talked about several times. In several different contexts, in several different ways, you've chosen to make a constitutional point, either expressing enthusiasm for overturning a 30-year-old long-settled precedent in Morrison v. Olson, or arguing for the unitary executive theory that Scalia advanced in his dissent there. Or I'll give you another quote. In a different 2016 speech, you said there, Justice Scalia never wrote a better opinion than his dissent in Morrison v. Olson, and you may have been commenting on the quality of his writing, but you go on to say you believe his views will one day be the law of the land.
There,
I assume here you're talking about the constitutional analysis in Scalia's dissent, and you're expressing a hope, an expectation that it'll someday be the law of the land. You sit before me as a nominee to be in a seat where that will be eminently within your reach.
but again, Senator, I just want to avoid melding a lot of different things into one because they're very important to keep distinct here, very important. The first is the independent counsel statute, and I view Morrison as only about the independent counsel statute, and I realize you may have a different view on that. But if it's only about the independent counsel statute, as I see it, and the independent counsel statute doesn't exist anymore, that's where, that's why Justice Kagan probably felt free to comment about Morrison as well. And then on special counsels, I've said what I've repeated many times here, on investigation and indictment of a sitting president. Number one, I've never taken a position on it. And number two, it's important to underscore the Justice Department for 45 years. This is the Justice Department, not me. The Justice Department for 45 years has taken the position in written opinions that a sitting president may not be indicted while in office, but it has to be deferred, not immunity, but a deferral. And Randy Moss, who was head of President Clinton's Office of Legal Counsel, wrote a very long opinion on that. He's now President Obama appointed district judge in D.C. and an excellent district judge. I'm not saying I agree with that or disagree with that. I'm saying that's the consistent Justice Department view for 45 years. So before a case like this would come before the courts, whether I'm on the D.C. Circuit or otherwise, the Justice Department presumably would have to change its position. That's one. Two, a prosecutor at some point in the future would have to decide to seek an indictment of a sitting president at some point. And three, it would have to be challenged in court. Then all the briefs and arguments, and then it would come up on appeal to me in the D.C. Circuit. So there's a lot of things that would have to happen before this hypothetical that you're presenting even comes to pass. And if it does come to pass, you can be assured that I have not taken a position on the constitutional issue that you're raising on that specific question, at least as I understand the question. And that's totally distinct from the Morrison issue as I understand it.
Well, and I'll tell you again, the reason this has been gravely concerning to me, why I raised it in our meeting and sent you a letter about it, and why I've dedicated so much time to this question is I really don't view the issue in the independent counsel statute and the Morrison v. Olson decision as dealing with some now long past statute and some really sort of obscure and now not particularly relevant issue. I think the reason you reached out and volunteered that you'd love to overturn Morrison v. Olson isn't because Scalia wrote a powerful and moving dissent. It's because of a view of the executive branch having all the power of the executive branch in the president's hands that you've articulated across speeches, interviews, writings, and an opinion this year. I think that's really your view of the executive branch.
But I've not
It
said,
raises real
I've never
concerns
said that. I've never said that, number one. So there are two issues here, and I want to be very, very clear on them so people understand that too. One
This
is
is how I read your dissent in PHH this year, is arguing, advancing a unitary executive theory.
and I refer to a single president, but same concept. But
Single president means the president is the chief law enforcement officer of the United States and should have all the power of the executive branch, including the ability to fire at will, which is really what's at issue in all these articles and cases. The ability to fire at will a special prosecutor, correct?
so I have taken as a given in all these cases.
That's a yes or no. Is that what you mean?
I just want to be real clear, and I'm going to be repeating myself for about the 10th time, but I have repeatedly said that Humphrey's executor is the precedent that allows independent agencies, and that I have applied time after time. That's point one. Point two is I've specifically said what I've said about special counsel systems being the traditional mechanism. Point three is I've never taken a position on the constitutionality of indicting or investigating a sitting president. And point four is that the question of who controls the executive
power. I've got just a minute or two left, if I might. On that point that you've never taken a position on the constitutionality of investigating a president, it was this American Spectator article where you said, and I'm quoting, if there's an allegation of presidential wrongdoing, a congressional inquiry should take precedence over the criminal investigation including an investigation of any presidential associates. This American Spectator article was striking to me, this one in which you said it was constitutionally dubious for a criminal prosecutor to investigate a president, because you suggested not just that the president should not be criminally investigated as during his term, but that even his associates shouldn't be held accountable through the criminal justice system. You mentioned you might make an exception for violent crime, and I
Now, that's,
a last question for you, if I might. What if a presidential aide commits an assault, an act of domestic violence?
I never said anything like that, Senator, in terms of.
I'll let you answer that, and then we'll go on.
And I'd like
the
to
next
conclude,
bit.
if I might.
Yeah, I've not said anything approaching what your broad description is. There's always been a question, based on the Justice Department's own position for the last 45 years, the Justice Department's own position assumes that the proper thing to do is to wait for indictment, is that occurs after a president leaves office, whether that's because the term ends or because of the impeachment process. And that's how the Justice Department, again, for 45 years, that's been the law. But that's not my law. That's the Justice Department's law, again, with Randy Moss writing the most important opinion on that.
I recognize I'm out of time. I'd like to conclude, if I might, Mr. Chairman, briefly. I look forward to continuing this line of discussion with you in our next round, Judge. I do think that there is good reason for members of this committee, myself, principally, to be concerned about a whole range of things that you've said, that you've written, and that you've decided as a judge about whether or not a president can be held accountable. I think the ability of a special counsel to conduct an independent investigation of the president is foundational to the rule of law.
I've said the same thing.
And
Okay.
I look forward to a next round where we can investigate
said the
that
exact
more
same
thoroughly.
thing.
But frankly, Judge,
Yeah.
your views about executive power, as I think you have detailed, your statements about what you'd like to overturn and what limits you think there should be, really leave me concerned. And it's because of our current context. It's because of the environment we're operating in. And I look forward to another round and to more questions.
I look
Thank you.
forward to it, but just to reiterate, what you said about special counsels is exactly what my article said in '99, exactly what PHH said.